All right, good morning, everyone, and welcome to the first. Is this the first? No, it's not the first. The second risk reduction class of the year. The first one was forms, the December forms release. This one is the 2025 new laws that affect real estate. So, gonna go through the most important laws. Quite a few laws were passed, but there's only a small handful that have a big impact on real estate. And I'm going to cover all of those today. Before we get started, I want to open with a tip. And keep in mind, another thing I always say is sometimes the tips are worth more than the content. So this might be the most valuable thing you get out of today's class. I hope not. I hope you get a lot more. But I want to bring this up because it's come up again and it can be pretty serious. So what am I talking about? I'm talking about protecting your right to compensation when you have listings, and now also when you have buyer representation agreements after your listing or buyer representation has expired. So, everybody knows you take a listing, maybe you take the listing for 6 months, and in 6 months it doesn't sell, but a couple of buyers have been in the property. Even sometimes, and this has happened a handful of times, believe it or not, sometimes, 3 days before the listing expires, a buyer writes an offer and you're in the middle of negotiating and the offer expires. You are not entitled to compensation or protecting a buyer unless you follow specific procedures. Simply being in the middle of negotiating a contract doesn't give you any right to compensation on that contract when the listing expires or the buyer representation agreement expires. Only when the purchase agreement is accepted, then your listing agreement, it doesn't matter. With an accepted offer, that the right to compensation survives an expired listing or BRBC if the offer is in fact fully executed and fully accepted. But again, this scenario comes up often, and that is we're in the middle of negotiating. A counter is out to the buyer. The buyer is indicating he's going to accept it, but it hasn't been received yet, and the listing expired. You're dead unless you do certain things. So let me review quickly what you must do to protect yourself. So there's a clause in the contract, both the listing contract and the buyer representation contract, called the continuation period clause. And that's the clause that a lot of us refer to as the protection clause, protecting your right to compensation when you're in the middle of negotiating with a buyer or a seller and your listing expires. So in the RLA, paragraph 2C3, there's a blank, it's in the grid. Paragraph 2 is the grid. In C3, there's a blank where how long can your continuation period be? And again, that's your protection period. So you could put down 365 days after this listing expires. If any buyer who's entered the property buys the property, you don't even need to be in the middle of negotiating. If that buyer entered the property or a direct relative of that buyer entered the property, uh, and you do two things. Number one, you fill in that blank. You got to have a number of days. Leaving that blank, you have 0 days. A blank is the same as zero. So you put in 365 or you put in 180, whatever you want to put. On the RLA, you can put anything up to 2 years because an RLA can be up to 2 years long. In a BRBC, you can't put more than 3 months. So you fill that in. That's part one. And then part two, and this is the important, well, both of them are important, but the second step, and this is the one that agents forget frequently, and that is you have to give notice of prospective buyers to the seller before the expiration or cancellation. Some of us have been in real estate for a long time. Now that changed quite a while ago. But before that, you gave notice up to, I think it was 3 days after expiration. Well, that's been ruled illegal And so CAR changed the form to be you give the notice before expiration. So if your listing expires tomorrow, give a notice of anybody that's been in that property that you want to protect. And for heaven's sakes, if you're in the middle of negotiating with a buyer, give that notice. The notice is an NP like Paul, B like Baker, notice of prospective buyers. And that requirement is detailed in the RLA in paragraph 4D, like David, 2. So if you got any questions on that, you can add it to the questions we'll talk about at the end of the presentation. But I do want to share that with you. Uh, you know, never want to incriminate the guilty by mentioning names, but even now we're in the middle of trying to uh, preserve our right to compensation on an expired listing where no notice was given by the listing agent, and so that complicates your ability to be compensated if you don't give that notice. All right, let's get into today's presentation. I'm going to share my screen before I do that. And Lindsay, how do I do that? Let's see, share. All right, share. Okay, everybody can see my screen, I hope.
Yes.
And, let me open up my presentation. All right, everybody can see that. So as always, I open up with a way to contact me. And again, if you call my cell during business hours, I apologize if I don't get back to you. I don't ignore my cell, like I won't call you because you called my cell during business hours, but I just don't have the cell in front of me. I don't have the ringer on because it rings and I'm in the middle of talking to other people. I may be in a meeting in my office. I may be on another call. So my cell sits on the side of my desk with the ringer off, and here comes a message in the middle of the day, and I don't know about it until maybe 2 or 3 hours later, because then once in a while I do check the phone, and now I see the message. So a better way to reach me during business hours, and for me that goes a little bit past 5 for sure. I would say well past 5, but sometimes not too far past, maybe 5:30, 6 o'clock. But after hours, call my cell for sure. But during business hours, much better. I'll be much more responsive to calling my direct line right there. And of course, you can email me at any time. I keep my email open the entire time I'm in the office. It's the first thing I open up, and I never close it. In fact, it's probably open behind this presentation. And finally, evenings and weekends, of course, then call my cell. Not to be too personal, but I don't keep the ringer on. It disturbs my wife, and she had a medical issue and needs all of her rest. So I don't want to wake her up if she's sleeping. So I don't have the ringer on often, but I keep the cell near me, and it lights up when I do get a call, and I'll see that pretty quickly, evenings and weekends. All right. A couple of people have tried to call me during the middle of the day on my cell. And again, I get back to them, but not as quickly as I would like. If you've got a problem, a question, I want to be as responsive as possible. Okay. 2025 new laws that impact your real estate practice. That's what we're going to talk about today. And we're going to talk about, I think, 8 laws. Got a little outline of what we'll talk about. And then I'm going to go into detail on each of them, some in a little more detail because it'll be important for you to understand the law. Others pretty straightforward. So what laws are we going to talk about? Well, we're going to talk about the buyer representation agreement. That's not going to be real surprising to you. We've been talking about it quite a bit, but I want to review with you AB 2992, which is codifying in California the requirement to have a buyer representation agreement. We're already required because we're NAR members and it's part of the NAR settlement. But AB 2992 has some differences, and I want to review that with you. We're also going to talk about the domestic water storage tank disclosure. We have a few agents who work in rural areas, and if you work in a rural area, you'll want to be familiar with this disclosure. We're going to talk about the replacement of gas-powered appliances and the electrical systems inspection advisory law. We're going to talk about the balcony inspection deadline extension. We're going to talk about exemption to contractor license law. This is, to me, a pretty big deal because agents get involved with working with handymen all the time, sometimes on behalf of their seller, and sometimes because the seller is hiring a handyman. And I just want to review with you the law. And you can do what you want, but you should be aware of what your requirements are in law and on contract. Contract says the repairs have to be done according to the building code, and the building code and the civil code requires licensed contractors in certain circumstances, even often handyman do the work. And if the buyer's okay with it, the seller's okay with it, or if you change the contract and say you're going to hire a handyman to do the work, then that's going to help you a little bit. So you need to know this law. ADU permitting, a pretty interesting law. You should be aware of that. Updates to the pools and spa safety requirements. Not a big deal now, but it's something you should be aware of for sure. And it could be a big deal going forward. Right now, we don't have a lot of foreclosure or notice of default and trustee sales. But if we do, this law is going to have a big impact on that. And then finally, I do want to update the foreclosure timeline relative to this new law, AB 2424. So that's what we're going to cover. So let's jump right into it. First law we're going to talk about is the new AB 2992. It went into effect January 1, and it codifies the requirement for buyer representation agreement for all agents. Prior to January 1, only NAR members were required to have buyer representation agreements. Now everybody does. And so I want to review this law with you, talk about the differences and which applies, either the AB 2992 or the NAR settlement. I will tell you in general, the NAR settlement will apply most of the time, except in cases where AB 2992 is more stringent than the NAR settlement. So it requires a buyer representation agreement to be executed when a real estate agent represents a buyer in the purchase of real property. Keep in mind, this law does not require a buyer to sign a buyer representation agreement. It requires an agent to have one signed by the buyer if they are going to represent the buyer in the purchase of real property. There's no law that says a buyer has to sign a representation agreement and be represented by a buyer if they choose not to. But there is a law now, and it's part of the NAR settlement as well. An agent cannot represent a buyer unless they have a representation agreement signed by that buyer. Now, the application of the law, this law, 2992, applies to the following transactions, and it's pretty much all transfer of title transactions. Here's the list. Any real property improved with 1 to 4 dwelling units. That's, by the way, the same requirement of the NAR settlement. This is where the law differs from the NAR settlement. Multi-unit residential property with more than 4 units. NAR settlement doesn't cover that. This law does. And so it doesn't matter that NAR doesn't require it. The settlement doesn't require it. Civil code does. So if you're representing an investment buyer buying a multi-unit complex, you have to have a buyer representation agreement. Commercial real property, NAR settlement does not cover that. This law does. If you're representing a buyer in the purchase of commercial property, you have to have a buyer representation agreement. Vacant land required. Ground leases with improvements. We don't get into that too much, but if you do, this is a representation agreement required. Manufactured homes or mobile homes when they're offered for sale or sold through a real estate agent. And then the real estate agent has to have a representation agreement. So this list of covered transaction, as I just reviewed with you, is quite a bit different than the NAR settlement and the MLS rules. NAR settlement MLS rules require a buyer representation to be executed only for residential properties 1 to 4. That first thing on the list I just reviewed. AB 2992 prevails over the NAR settlement and MLS rules. So so starting January 1 of this year, basically any real property where you represented a buyer would require a buyer representation agreement. So hope that's kind of clear. And if not, put something in the chat, or or when Lindsay covers the questions, we'll explain that further. All right, the law does not apply to leases or rental agreements. See, there's no transfer of title. So you do not need a buyer representation agreement to represent a tenant in trying to find a property to rent. Okay, or to sale of state or federal land, again, not required. And then finally, the law does not require a buyer representation agreement to perform loan brokering services. Nobody on this call performs loan brokering services, so but if an agent did, they do not have to have a buyer representation agreement to be a loan agent for a buyer. Now, the timing. When must an agent execute a buyer representation agreement with the buyer? AB 2992 says as soon as practicable, but not later, no later than the execution of the buyer's offer to purchase. Sort of like an AD, an agency disclosure. When do you give it? Well, the law says give it as soon as you can, whenever it's practicable, but never later than prior to the execution of a real estate contract. Well, same with the buyer representation agreement. Give it as soon as practicable, but never later than the execution of a buyer offer to purchase. The DRE is going to interpret what they consider as soon as practicable. They've put us on notice. The CAR and DRE talked, and sometime later this year, they think it'll be maybe 6 months. Of course, it's going to be 6 months. It's a state government operation. So in 6 months, they'll tell us what they think as soon as practicable means, and how they will enforce that law. Now, note, this is different than the NAR settlement and the MLS rules. The NAR settlement MLS rules require a buyer representation agreement, as you know, before an agent shows the property. The NAR settlement and MLS rules prevail over AB 2992. So I've seen this on in chats and things like that, real estate chats and that. Oh, good, AB 2992, made it possible for us now to show property without having a representation agreement to show property. No, that is not true. I mean, AB does say that. AB 29 does say that, but you're bound by a higher regulation, and that's the NAR settlement MLS rules. So everybody on this call, you have to have a buyer representation agreement before you show property. Nothing new there. You've been struggling with that. Some of you, most of you worked through that and figured out how to do that effectively. And that has not changed because of AB 2992. Why? Because your membership can have a more stringent requirement as long as it's not unlawful. And it's not unlawful to have a buyer sign a representation agreement before you before you show property. Now, the required contents of a buyer representation agreement, you want to share them with you. And the reason I want to tell you that is because if you leave anything blank in a BRBC, not only are you creating an unenforceable contract, but you're violating civil code. So be aware of that. And so make sure, what's the compensation? How much is the buyer's agent going to be paid? What services are you going to render for this? When is the compensation due? And how is the contract terminated? Now, the good news is you don't have to struggle with it. You just have to fill in the blanks on the BRBC, because the BRBC in the boilerplate covers all of this. See, these terms are incorporated in the BRBC, and they're also incorporated in the PSRA, which I often call the BRBC Light. I stole that term, I think, from Neil. And the property showing and representation agreement is also a buyer representation agreement. So these things are in there, in some cases blanks. So you have to fill in the blanks. Now, the term of the buyer representation agreement, this is important to keep in mind. I think most of you have adjusted to this. It cannot last longer than 3 months, and it is 3 months, not 90 days. Now, the only time that matters is if your representation period incorporates February, and quite possibly only if it starts in February, because February might be 28 days, but it counts as a month. So, but if you started a BRBC in March or later, you're probably fine by the 90 days, because that won't be longer than the 3 months. All right. Now, this restriction on how long a buyer representation agreement can last does not apply to corporations, LLCs, or partnerships. So once in a while, some of you do represent LLCs, flippers. Sometimes you do represent corporations. So you can have a buyer representation agreement as long as you like, as long as the client likes, if it's a corporation, LLC, or partnership. Now, renewals, how is the contract renewed? Well, you can have an unlimited number of renewals. That's an important note to make. However, they can't renew automatically. You have to have a uniquely executed document each time you renew the buyer representation agreement. And the renewal must be in writing, dated, and signed by all parties. And finally, the maximum renewal term for each renewal is 3 months. So you can't list it, can't have a buyer representation agreement for 3 months and then renew it for 4 additional months. No, it's got to be an additional 3 or less months. An AD must be provided, of course. The representation agreement in violation of the provisions of AB 2992 is void and unenforceable. So if you have an agreement that doesn't conform to the law, your agreement is not enforceable. And violations of the AB 2992 is a violation of licensing law and is subject to discipline by the DRE. So hopefully that clarifies any questions you have about the differences and what do you do and how do you handle some of the things that are a little different in the law and in the NAR settlement. Let's talk about the domestic water storage tank disclosure. That's a new disclosure. And any seller who received domestic water tank storage assistance or was aware that the property received such assistance, and the property currently still has this assistance, in other words, a domestic water storage tank that they acquired through the assistance that's offered to them, shall deliver to the buyer a disclosure stating that whether or not the domestic water tank is provided through assistance. Now, assistance is any county, community water system, local public agency, or a nonprofit organization. So what is this law all about? Well, you can be sort of sensitive to this due to the LA fires. Whenever there's a fire in rural areas, sometimes the water storage system is affected by that fire, put out of commission. And sometimes rather than the homeowner putting the water storage system and getting the pump reactivated and all that kind of stuff, they get a domestic water storage tank from the county or the community or a public agency or a nonprofit. We're pretty sensitive as a society that, people living on property need to have access to drinking water and water for other purposes. So sometimes, especially after natural disasters such as fires, homeowners will end up, who live in rural areas, will end up with a water tank provided to them by one of these entities that they didn't buy and put on the property initially. So that's what this is about. So that has to be disclosed to the buyer. Buyer sees a water tank and just assumes it's, attached to the property through piping and all of that. So it's real property. May not be. It may be owned by the county and is just there because the county is providing assistance. So that's what's got to be disclosed. You know, so what they're disclosing is that the water storage tank was made available to households that had private water wells that had gone dry or had been destroyed through a drought or a wildfire, other natural disaster, and their original system was some way non-functioning. And so they got this temporary water storage tank. Sorry about that. And the domestic water storage tank provided might not convey with the property, because the seller doesn't own it. So that's a disclosure that has to be made. And due to water well issues that led to this property obtaining assistance, the buyer is advised to get an inspection of the water well and have a professional evaluate the availability of water to the property. So that's all part of the disclosure. And it's codified in the civil code. This disclosure requirement, SB 1399, is codified in 1102. What's that mean? It's like a TDS. This disclosure has the same, like I say in the slide, application exemptions or termination rights as a TDS does. So when you give this disclosure, you want to give it timely. The buyer has an absolute right to cancel within 5 days of receiving the disclosure, and that cannot be waived. So for those of you that have this, want to pay attention to this a little bit, make sure you get this disclosure out in a timely manner and deal with it appropriately. And again, a few of you work in rural areas where this very much could have an impact, especially after a natural disaster. And there may be some parts of San Diego County where homeowners still have these temporary tanks on their property. This applies to residential property, 1 to 4 units, or manufactured or mobile homes, just like a TDS. It's very similar. The provisions of this is very similar to TDS. Has the same exemptions as a TDS. In other words, if it's a probate sale, a bankruptcy, a foreclosure, your successor trustees who have not lived in the property in the past year, they would be exempt from this disclosure. Now, this disclosure is made part of the SPQ, and that's in the revised SPQ. I reviewed that in our last session. Question 9B talks about it. So all you have to worry about is making sure you get the SPQ over to the buyer in a timely manner, because you don't want to deliver it late and then the buyer use that to cancel when he's removed all his contingencies, because this cannot be waived, their right to cancel. And it's not part of the TDS. The law didn't make it required to be added to the TDS. It just said the disclosure had to be made, and the SPQ is required when a TDS is required by contract. But you do have to give the SPQ, even if seller doesn't want to. They have to, because it has this legally required disclosure. And again, that's for properties that have domestic water storage tanks. Now, SB 282, replacement of gas-powered appliances and electrical system inspection advisory. So the first part of the law is the seller is required, if aware, to make a disclosure that the replacement of gas-powered appliances may not be legal. Now, I don't want to get in the weeds, but the federal government has weighed in on that a little bit. Actually, the courts have. And other type regulations in California requiring that, for example, new construction in certain areas, you could not use gas appliances. Well, people in those areas took their county or their city to court, and in the case of Oakland, they won, and it was challenged in the Ninth Circuit, and the Ninth Circuit said that's an unconstitutional law. So this law, this part of the law may eventually be scrapped, but it may not be, because that lawsuit only covered that particular entity and the requirement for new construction to have electrical appliances in commercial properties and not allow gas. So that got replaced, but that's sort of the leading edge of where this law is going. Right now, many municipalities throughout the state have regulations, ordinances prohibiting or restricting the ability to replace a gas-powered appliance with another gas-powered appliance. You have to have an electric appliance. So until that's all shaken out, the seller will have to disclose if they're aware of a local ordinance. Now, if they're not aware, they can't disclose it. But now here's another interesting rub to this law. Really weird the way they wrote it. The seller has to disclose if his agent is aware or her agent is aware. Well, how does the seller know? I guess you ask. I don't know. So to handle this law, Carr is looking into perhaps changing the AVID so that the seller doesn't run afoul of the law because he should have known his agent knew, but he didn't really follow up on it. So that's sort of a weird thing. Now, as you're going to see in a minute, this law is not in effect yet. Now, the second part of the law is you provide a statutory notice to a buyer advising the buyer to have the electrical system inspected. It's just a notice. The buyer doesn't have to have it inspected, but the law that when it does go into effect states that the buyer received from the seller or the seller's agent a advisory to have the electrical system inspected. And the reason for that is a lot of properties have, inadequate electrical systems for like charging stations for electric vehicles. You don't have enough amperage to add a charging station to your house because your house is 50 years old and you have a 75 amp panel or something like that, some kind of tiny panel. And so the seller may or may not know whether the system is adequate. That's not what they're saying. They simply have to provide a buyer with an advisory to have the electrical system inspected. And then that inspection will say, yeah, you got barely enough power even to run your appliances now, but if you buy an electric vehicle, you won't have enough power to put in a charger. So that's the purpose for that law. Now, this law won't be effective until January 1st of 2026, but it did get passed in 25, and it is pretty significant, so I wanted to put it in this list so you can understand what's coming. So you will be seeing some revisions to the SBQ. The SBQ is already, I think, revised about, well, it is revised about the domestic water storage. I don't think it's been revised yet about the advisory for the or whether the agent or the seller knows if there's any local ordinances. But that'll probably appear on both the SBQ and the AVID in the future. All right, balcony inspection deadline extension. That's good news for a lot of property owners. It extends the deadline to have wooden balconies and other elevated elements for buildings with 3 or more units from January 1st, which is passed, to January of 25 to January 1st of 2026. It does not apply to condominiums. So condominiums that have a multi-unit building and has an elevated balcony or stairs or deck elevated more than, I think it's 5 feet, it might be 6, and having substantially wood supporting components, they still have to have their property inspected. It should have already been inspected. So condominiums, this extension deadline doesn't affect, but for properties that are not condominiums, the property owners have until 2026, January 1 of 2026 to inspect. So nothing changes if you're selling a condominium. You're still going to want to address the results of the inspection because those inspections should have already occurred. The extension may not apply if there's a local jurisdiction that has a more stringent inspection deadline requirement. I'm not aware of any in the county. I did a little research. I didn't find any, but you might ask the homeowner and to see if they are aware of a more stringent inspection requirement. All right, exemption of contractor's license law. This helps in many ways, but I want to kind of caution you to be careful when you use handyman. You're welcome to use a handyman, but you might be doing it in violation of the law. Now, you can do it yourself. A homeowner can do it themselves. We're not here to police anybody, but as a licensed real estate agent, you want to be careful about, at the very least, advising the seller that he might not want to use a handyman to make certain repairs or improvements as a result of a repair request, because it might be in violation of civil code. Now, that's always been an issue, and a lot of agents don't pay too much of attention to it. I guess the good news is it's going to be less of an issue going forward because the dollar amount was doubled. So before, if you had to pay the handyman $600 to make repairs, that was in violation of civil code. The handyman was in violation of civil code, and it was in violation of the contract, because the contract says you don't violate the civil code. So you'd have to hire a licensed contractor. Hire a handyman to, fix something and it costs $300 in the past, that's perfectly fine. Have a handyman fix something that costs $700 in the past was a violation of the law. And it comes up every once in a while, but not a lot. But what my concern is, you simply advise the seller. We've had some buyers insist, after the seller's paid a handyman to make repairs, that the contract said that you had to hire a licensed contractor if the civil code required it. And it does require it if you're paying the guy $600. Well, that number, like I said, is doubled. So let me see. Let me go through it with you. So the contractor's license law shall not apply when the aggregate contract price for labor and materials is less than $1,000. It used to be less than $500. It's now less than $1,000. So they upped it because it costs more money to get things fixed, I guess. Now, it's important to know that you can't evade this law by breaking the project up into little components. Fix this wall and these walls and that, charge me $700 for that, and then you fix the framing, and then in a separate contract put drywall on and charge me $600 for that, and then a third contract paint the wall and charge me $300. You can't do that. You can't in one project or undertaking by law. Now you do it. I'm not the police. I don't expect you to be the police. Your seller may very well want to have a handyman do $1,200 worth of work. You just want to be sure you advise the seller that he could have some complications with the buyer, especially because you're violating civil code and the contract says the repairs will be made in conformity to civil code. Now, the other exemption from this exemption, if you will, the license law will not apply if the construction does not require a building permit, okay? Or will apply if the construction does not require a building code. So you don't need to hire a contractor. I said building code, I mean building permit. You don't need to hire a contractor if the work being done doesn't require a permit. Now, this exemption does not apply. I hope I'm not confusing you, because it's got almost a double negative there. This exemption does not apply if you break the construction project up. Use different people or different contractors. The project has to be what is governed there. So that's the first thing. And then dividing the labor up, like I said in my example, to keep it under 1,000, it doesn't apply. And then finally, this is kind of surprised me. that it's in the code, but it is. If your handyman has a helper that he pays, that he's not exempt. It's only a single person doing handyman work for less than $1,000. But if the handyman has an employee, if you will, he can't do this work. If it's because the exemption won't apply by code. Hopefully that's clear to everybody. ADU permitting. This is kind of a big deal, I think, because it's going to help a lot of homeowners with ADUs. So 2533 extends the ADU amnesty law regarding unpermitted ADUs and junior ADUs. And junior ADUs are substantially a specific dwelling unit within a larger dwelling unit. So what the heck is that? Well, most common is garage conversions. So a garage conversion is a junior ADU. It's not a unique standing ADU building. It's an ADU within the original building. So it extends the amnesty law for unpermitted ADUs and junior AD units that were built prior to 2020. And what is that amnesty? Well, that amnesty requires cities and counties to provide a clear process for homeowners to obtain permits for their unpermitted ADUs. I don't want to get in the weeds here because I promised you we wouldn't run long, and already we're going to push up against the deadline. Call me if this is an issue, but if you have a homeowner renting out an unpermitted ADU, he may have a tenant for life. And that tenant can legally avoid paying rent. And the homeowner cannot legally evict the tenant. If you followed that, you're going to say, what? That's crazy. Well, there's a civil code. And by the way, it's been upheld by courts. There are more than a few instances where tenants have rented unpermitted facilities or facilities that were improved, and the improvements were unpermitted. They figured this out. They stopped paying rent. And when an unlawful detainer went to court, the judge threw it out. Why? Because there's a civil code that says you are not entitled to rent on a property that is not permitted. So you build an unpermitted ADU and then rent it out, you're doing it at your own risk. And so if you have any questions about it, call me and we can talk about it a little bit on this call. I don't want to get in the weeds here too much. But the good news is, so you built an ADU, you didn't get a permit, now you're thinking, oh my gosh, I want to rent it. And I talked to Walt and he sort of scared the heck out of me. And they could tell me, wanted me to scare the other side as much as I scared the agent. Okay, I guess I'll do that. But you want to maybe go ahead and get a permit after the fact. Well, this law allows that. If it was built before 2020, you can go in and perhaps get a permit because they have to provide a clear process for you to obtain a permit after the fact on unpermitted units. It prohibits local agencies from denying a permit that was for an unpermitted ADU or junior ADU that was constructed before the 1st of 2020. Unless the local agent makes a finding that the correcting a violation is necessary to bring the improvement up to building standards. So in other words, they cannot or they're not required to issue a permit on an unpermitted structure if that structure was built in violation of building standards. So you built an ADU and you didn't get a permit, but you wouldn't know it looks just fine. You can get a permit. You build an ADU, but you kind of save on money, and so you only made the ceilings 7 feet, not 8 feet. That's a violation of building standards, and you won't be able to get a permit for that. City and counties must inform the public that an ADU permit amnesty exists, and they can do that through public services, through a permitting checklist, or local agency website. They have to let public know, look, come on in and get your permits, even though you're a little late. A checklist of health and safety violations for which a permit would be denied. They have to tell you that. So here's when you can't get a permit. And of course, one of the reasons would be it's not in conformity to current building code standards. They also must inform the homeowner before submitting an application for a minute homeowner that they must allow and inform the homeowner they can get one, have a third party look at the property to see if there's any health and safety violations that would prevent the homeowner from getting a permit. And then finally, a homeowner applying for a permit for a previously unpermitted ADU or JUAD shall not be required to pay impact fees, connection fees, or capacity fees, except when a utility infrastructure modification is required. So in other words, you can't prevent a homeowner from getting this retroactive, if you will, permit by charging them a fortune for it. You can't charge extra fees and impact fees and things like that. So the state is sort of on record of wanting ADUs, and they recognize that these ADUs should be permitted. And they also recognize that a lot of people have ADUs that weren't permitted. And here's a chance now to get them permitted. All right, updates to pool and spa and safety requirements. It's a big deal, but this is going to be real quick, real simple. The law requires a home inspector that's looking at a home with a pool to include an inspection report in the inspection report on the drowning prevention safety features. And they must make a note that whether or not the drowning prevention safety features are in good repair or not, are operable, and are appropriately labeled. So that's going to impact physical inspections, and I presumably reputable inspectors, licensed inspectors that are inspecting properties with pools will be aware of this, and we as agents should sort of make sure that that's a part of any physical inspection report when you get it. Skip through it, make sure they've covered this. Postponement of foreclosure sale and minimum property sale price. So I'm going to wrap it up with this one, and this is kind of interesting. If you are unable to pay your mortgage, you're going to have a long time to figure out how to fix that problem, and you'll see in a minute. Now, the law says that when you're foreclosing on a residential 1 to 4 unit property, the trustee must grant an additional 45 days beyond the scheduled date of sale if the trustee receives a listing agreement from the trustor. The trustor is the debtor, the homeowner, at least 5 business days before the scheduled sale. So if they get a notice from the seller, a listing agreement, hey, I listed my property and the sale's 7 days from now, they have to give you an additional 45 days. It's an additional 45 days. So you get to 7 days before the trustee sale. The 45 days doesn't start until the trustee sale was scheduled. And then the trustee does not do the trustee sale. He grants the homeowner another 45 days. So that's a pretty nice thing if you're in trouble and you trying to protect your property, or in this case, trying to sell it and get your equity out of it before a foreclosure actually occurs. Now, the requirements to qualify for this 45-day extension, I'll run through them real briefly. The trustee has to receive a listing agreement 5 days before the sale. The property has to be listed with a California licensed real estate broker. The property must be placed in a publicly available marketing platform. In other words, the MLS. It has to be either an MLS or on a publicly available website. I think having it just on a website might not be enough. I think the MLS is pretty much what's going to be required. So it probably has to be in the MLS. The listing agreement has to be certified, sent by certified mail, so that there's some documentation that the trustee had it, and the tracking information, the certified mail or overnight courier, must get a recipient's signature with a date and time of receipt. So pretty straightforward. Now, this is interesting. If the scheduled date of the trustee sale is postponed, so the first step is, all right, I postponed it because I listed my property due to the receipt of the trustee by the listing agreement. The trustee shall postpone the scheduled trustee sale an additional 45 days beyond the scheduled date of sale if the trustee receives an executed purchase contract. So now you got 90 days because you sold the house. Now, if you didn't sell the house, you don't have an executed purchase contract. You only got the 45-day extension. But now you have a 90-day extension, and technically it works out to be 85 days because of the way this is structured. Won't get into the weeds there too much on explaining that. They have to receive notice of the purchase agreement 5 days before the scheduled sale. Now, the requirements to qualify for this additional 45-day postponement because you sold the property. Trustee receives an executed purchase contract 5 days before the scheduled sale. And by the way, this is the new scheduled sale, not the original scheduled sale, because you rescheduled it as a result of the 45-day extension because you got a listing. Now you get another 45 days, and technically you get 40 days because of the way the notices work, because you sold the house. So you want to close that escrow within 40 days of the new extended deadline due to having the listing of the property extension. The purchase agreement must be a bona fide agreement and fully executed. It must include the name of the buyer, the sale price, the closing date, and must be accepted by an escrow agent. In other words, that part of the offer in the last page where the escrow officer acknowledges the purchase contract, that must be executed. Purchase price must be equal to or greater than the balance of all the unpaid liens. In other words, no short sales. And purchase agreement must be sent by certified mail, just like the listing agreement. Tracking information, just like the listing agreement. And finally, this postponement for the sale can only be used once. And that's their concern that a seller would get straw buyers to execute multiple purchase contracts one after another and keep getting this 45-day extension because they sold the property, and the lender can never foreclose. So no, the extension for a purchase agreement being in place can only be used one time. Now the second part of this law, and I think this is an interesting part also, the trustee is prohibited from selling a property containing 4 or less, actually, I should have written it that way, 4 or less units at the trustee's sale for less than 67% of the fair market value. The property remains unsold after the sale, then the trustee must postpone the sale an additional 7 days, and then they're authorized to accept the lowest bidder. So if they don't get something that's within that percentage, they can then put it back up for sale and go through a bid. All right, so I want to just review in the last couple of minutes here, then I'm going to wrap this up, just literally in a minute or two, the new sort of foreclosure timeline. And I've got a handout. I'll maybe post that in Agent Hub for you. But if this is what you might want to think about a little bit. Under California law, after a notice of default is recorded, that you can't schedule a trustee sale for approximately 110 days. So once they record the notice of default, the homeowner's got 110 days, just slightly less, approximately right around there. Okay. Since 2021, if the property has a federally insured loan on it, Fannie Mae, Freddie Mac loan, which most properties have, including FHA and VA, if the RESPA Act applies, then the notice of default can't be filed for 120 days after the loan becomes delinquent. So you can file, quicker on a non-RESPA property, but there are not many properties in California that are non-RESPA. All right. So therefore, the total time the buyer has from default to sale is 230 days, 120 plus 110. That exists right now. A lot of people are not aware of this RESPA extension, so to speak. Under the new law, in addition to the 230-day timeline, due to AB 2424 that I just reviewed, a homeowner could get an additional 85 more days. So, delivery of the listing to the trustee gives them 45 more days, and delivery of a purchase contract, like I said, technically it's 40 days because of the notices. So you get, another 85 more days, which puts you out to like 300 and some odd days from the time you default on the loan before there can be a trustee sale. So hopefully everybody got something out of this. I appreciate your attention. Lindsay, do we have any questions?
Yeah, there's a few in the chat. Nora asks, I think this is regarding renewing the BRBC. She just asks, even when renewing after 3 months, maybe she can clarify what she means by that. Nora, are you there? Oh,
Yeah,
she's
hello.
Yeah,
Hey, Nora.
Yeah, he answered it already. Right after that, he
Okay.
said even after renewing 3 months, it's
Okay.
still an additional 3 months.
Perfect.
Thank you.
yeah, you can
Sure.
keep renewing it, not more than 3 months at a time, but you can renew it over and over and over and over again.
Dennis Smith asks, does the general home inspection qualify for an electrical inspection for SB 282?
Does a what? I'm sorry.
Does the general home inspection qualify for an electrical inspection for SB 282?
Uh, well, again, there's no law that says it has to be inspected. So when you say, does it qualify, that'll be up to the homeowner. I would argue that you probably want an electrician to evaluate that. I'm not sure. I mean, some inspectors pretty knowledgeable, you know. So uh, where you who you consult with as a buyer to tell you. I mean, I had a general contractor's license, and I was pretty versed in electrical, really very versed in electrical. I can look at my property and tell you right now whether I have adequate amperage to my panel. I know exactly what to do. I know things like spaces, sub panels, and all that. I wouldn't do that for a living, but I could do it for myself. The seller is advised or is required to advise me to get it inspected. Now, if I choose to inspect it myself, I can do it. If I choose to let a home inspector tell me, I can do that. If I say, no, I want to hire an electrician, they're smarter than I am, I may not know as much as I think I know, I'm going to have an electrician look at it. You can do that. The law says the seller has to advise the buyer that he should get an inspection. So, the buyer can, make determine for himself who he trusts for that inspection. Hope that answered that question.
Dennis also asks, is that for different trades, like the same handyman for 600 plumbing and another ticket for 600 for electrical?
If it's the same project, no. And again, handyman, electrical and plumbing, regardless of the cost, handyman may not be allowed to do that by law. A licensed electrical contractor may be the one required to do it. I don't want to be quoted, but I think you could probably hire a handyman to install an outlet. I think that's probably okay. I don't know that you can hire a handyman to install a sub panel. I think the civil code requires a licensed electrician.
What about unpermitted ADUs and JADUs built after 2020?
That law, I apologize. I glanced around to try to figure out why the 2020 requirement, uh, and I couldn't find out why that is. So I'll research that some more and figure out what's magical about the 2020 deadline. There may be other things in the civil code I'm not thinking of that makes after 2020 impacts that, and that's what I want to look at.
And then Sissy has her hand raised.
Oh, hi, Walt.
I
Hi. I was wondering if someone is doing a small remodeling, for example, floors, tiles in the bathroom, kitchen counters, things like that. I understand for the plumbing and electric, it has to be licensed contractors for those. How about cosmetic things like even flooring or tiles in bathrooms and kitchen? Does that need to be licensed contractor as well?
Probably not. The challenge you've got is it's got to be less than $1,000.
So if it's over 1,000, it
Not
needs to be.
exempt. Right. So,
Mhm.
I mean, again, I'm quoting the law.
Mhm.
I'm acknowledging that the homeowner is going to hire a handyman to retile their kitchen, family room, dining area, and it's going to come to. By the way, it includes material and labor, so you could spend $1,000 on tile alone. Now, a licensed contractor by civil code is required. Now, where it impacts us as real estate agents is the RPA says we have to follow civil code. The repairs will be in conformity to civil code, and where required, be a licensed contractor. So can I hire a handyman to replace 4 broken tiles in my entry? Yeah, I think so. Not going to be $1,000. Can I hire a handyman to do the entire living room? Probably not. By civil code, therefore I'm in violation of the contract. I can still do it, but the buyer may say, I want that receipt, which they should, by the way, and they'll see a handyman receipt and they'll say, no, 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 this is more than $1,000. You were supposed to hire a licensed contractor to do this work. And now
Thank you.
you got an issue.
Thanks.
Yeah.
That's all the questions we have.
All right, folks, thanks for joining me. I hope that it was helpful. As always, reach out if I can do anything for you. And otherwise, have a great rest of the day, rest of the week, rest of the month, of your life.
Thank you, Walt.
Take care.
Bye, everybody.
Bye.